Michael Avenatti, the attorney for Stormy Daniels, the adult film star who says she had an affair with President Trump, has filed a motion in federal court seeking to depose both the president and his attorney, Michael Cohen, to ask both of them about the $130,000 payment that Cohen made to Ms. Daniels just before the 2016 election, seeking to ensure her silence about the alleged affair. And once again, White House Press Secretary Sarah Sanders fielded another question about it at today's briefing.
You haven't answered the subsequent question about whether the president was aware of the $130,000 payment that was made under an agreement in which he is explicitly named to keep Stormy Daniels silent. Can you answer that question? You were asked 3 weeks ago today and said you weren't aware. Are you aware now?
Look, the president has denied the allegations. We've spoken about this issue extensively, and I don't have anything else to add beyond that. Anything beyond that, I would refer you to the outside counsel.
I'm joined now by Stormy Daniels' attorney, Michael Avenatti. Thanks for being with us. What is the Michael Cohen's people want this to be an arbitration. They don't want this in open court, and that's what they said the contract calls for. They've tried to move it to federal court, which has a history of pushing things more into arbitration. How is that affecting what you're doing today in terms of pushing to be able to depose the president, to be able to depose Michael Cohen?
So what we filed just after midnight this morning, Anderson, was a preemptive motion. And what we've asked for is a number of things. We've asked for a 2-hour deposition of the president, a 2-hour deposition of Michael Cohen, some limited document requests where we can ask for specific documents to be produced, and then we want an expedited trial date on the issue as to whether an agreement was actually entered into. Now, why is that important? Because before their motion to compel arbitration can be heard, a fundamental question must be answered. And that question is whether there was an agreement to begin with. Right. Whether the parties actually reached a meeting of the minds and had an agreement. Without that agreement, you never get to the motion to compel arbitration. And that's under what's called the Federal Arbitration Act. So we've had this motion in the can for a while. We were expecting them to remove to federal court. They did, and we've now filed this motion, and we're highly confident that the court's going to grant it.
So if the president's not a signatory to the actual contract that was signed by Michael Cohen for the LLC and Stormy Daniels, why try to depose the president? What are the questions you want to put to him?
Well, I mean, we want to find out what the president knew, when he knew it, and what he did about it, if anything.
You're not talking about are you talking about the actual allegations of an affair, or did he know that Michael Cohen was doing this? Did he ask Michael Cohen to do this? Is this, essentially an in-kind campaign contribution? Or was the president involved in some way?
We're focused on the formation of the agreement and the terms of that agreement and what the president knew and when he knew it. We're not interested in what the White House spokesperson or deputy spokesperson has to say. We want to put the president under oath, and we're going to ask him some very simple questions. Normally, you're permitted 7 hours under the federal rules. We've only requested 2 of him and Mr. Cohen. It's one thing, Anderson, to lie to the press. It's another thing to potentially perjure yourself under oath. So we're going to ask those questions. We're highly confident in the motion.
Why are you say you're confident in the motion? What is there precedent for this? I mean, is this is an accelerated schedule you're asking for?
Well, this is not just some crazy notion that we thought up overnight. I mean, we've been looking at this for a number of weeks. We've been prepared for this. We've done our homework. There's extensive precedent in the Ninth Circuit. The president may not like the Ninth Circuit Court of Appeal.
He's spoken a lot about the Ninth Circuit.
Yes, I happen to love the Ninth Circuit Court of Appeal. It's the circuit in which I practice quite a bit. I think the judges are very learned and able, to say the least. And there's extensive precedent within the Ninth Circuit for the granting of this motion. It's really almost black letter law, what we're asking for. And I don't think, quite honestly, the president's team thought through this process of removing the case to federal court. They certainly did not see this coming.
Do you know how quickly you'll get a ruling on this?
Well, we've asked for a hearing on April 30th, and we're going to be before Judge Otero. I have some experience before Judge Otero. He's a very smart, no-nonsense federal judge. And when I say no nonsense, I mean no nonsense. And I'm confident that he's going to hear the motion on April 30th, and he's going to issue a decision shortly thereafter. And if the motion is granted, Anderson, I can envision us taking the deposition of Michael Cohen and the president within 30 or 45 days of the end of April.
Michael Avenatti, we'll see. Thanks very much. Appreciate it.